All right. Hello, everybody, and welcome to our Zoom webinar on the ABLE Act. My name is Lesley Mehalick. I am an adjunct professor with the American College, and I am also a practicing attorney. I work in Pennsylvania, as well as some other states, and I specifically practice in estate planning and special needs planning. And I'm very excited to bring this webinar on the ABLE Act to you. The ABLE Act truly has been one of the biggest pieces of legislation that we have had on behalf of persons with special needs in quite some time. As we will go through the presentation today, we have a lot of material to cover about the ABLE Act, and I'm really going to try to explain to you some of the differences between the ABLE Act and special needs trusts. The eventual legislation that we ended up with the ABLE Act ended up being a little bit more limited than the original proposals that were originally started in Congress. So what we have found is that the ABLE Act itself is not a complete replacement for special needs trusts, but instead it is a very important additional tool that a lot of persons with disabilities can use. So with that, let's get started. And lastly, I will say too that if we have a lot of material to cover today, so I am going to go through it all. We may not have time for all questions, but all questions will be sent to me as well, so I can always follow up with you after the presentation today. All right, the Achieving a Better Life Experience Act, or as we will call it throughout the webinar today, the ABLE Act. This was a law that was passed at the end of 2014. And what it did was it allowed states to enact their own legislation that would allow accounts to be created on behalf of individuals with disabilities. These are savings accounts that can be used on behalf of the person, but which specifically will not make them ineligible for their resource-dependent public benefits. So these are accounts that a person with disabilities is allowed to have, but still maintain eligibility for their public benefits. These accounts are administered by the state agencies. So right now, there's no option to self-administer your own ABLE account. Instead, it will be maintained and administered by the state agency. And they are modeled on state 529 plans, as we'll see. So again, the ABLE Act allows states to make laws for a person to establish his own savings account that operates in a very similar fashion to a 529 account. Specifically, the contributions that are made to the account, these are after tax contributions, so you do not get a federal income tax deduction when you make a contribution to an ABLE account. But once the contributions are made, they will grow income tax-free. And then when the money is withdrawn from the account, as long as the monies are used for qualified disability expenses, then there is no income tax on the growth portion. Just some examples of qualified disability expenses can include things like education, housing, transportation, financial planning, and a funeral. If withdrawals are made beyond these qualified disability expenses or QDEs, then there will be income tax on that growth portion, as well as a 10% penalty. So just as a 529 account, if it's used for tuition and the items it's allowed to be used for, then you don't have income tax on that growth portion. The ABLE account is treated in the same way. So again, these accounts and this legislation was very important because it offered a brand new way for persons with special needs to save for their future. And one of the major benefits of the ABLE accounts is that it truly gives the account beneficiary much more control and ownership over the money in the account. The beneficiaries of these accounts are going to be able to have a lot more freedom in how the monies are taken out and how they are used. So the whole goal of this legislation was really to promote independence for persons with special needs while still allowing them to stay eligible for their public benefits. So again, this is a very important additional tool for persons with special needs. So I think it's important for us to have a very brief discussion about what I mean when I say public benefits. You know, again, the ABLE accounts will not count as a resource against certain public benefits. So when I say that, what am I talking about? Well, the main ones that we are concerned with are the ones that are resource dependent. That means that a person cannot have too much liquid assets in their own name and still qualify for the benefit. So the major benefits that are resource dependent are supplemental security income, or SSI, and Medicaid, or medical assistance, as it is referred to in many states. So we're just going to go through those very briefly. Supplemental security income, or SSI, as it is commonly referred to. This is a benefit that a person can qualify for if he or she is disabled and if he has very little money in the bank in his own name. Specifically, the resource limit for SSI is only $2,000. It has been that same resource limit for decades now. It just has not increased for inflation, and there's been no laws to make that amount higher. So as you can imagine, only being able to have up to $2,000 in the bank is extremely limiting. The maximum benefit that a person can get from SSI right now in 2020 is $783 for an individual person. While that might not seem like too much, this benefit is extremely important for persons who are disabled and not otherwise able to maintain employment and have other income. But unfortunately, that $2,000 asset limit is extremely low, and you know, really it cannot provide too much freedom for persons who depend on SSI. Medicaid, or again, medical assistance as it's often referred to, is also an extremely important resource-dependent public benefit. Medicaid provides the broadest source of healthcare coverage that is available. It can, in addition to just regular medical coverage like doctor's visits and hospital visits and things like that, it is the only source of healthcare coverage that can pay for residential placements, full-time residential funding if needed, or for in-home supports that are designed to allow a person to stay in the community. For example, if you have a disabled adult who is mentally competent, but they want to keep living in their home, but if they're completely physically disabled and they need nursing assistance to help them transfer from the bed to a wheelchair in the morning, if they need assistance with self-care, with bathing, if they need help with house cleaning and cooking meals, with driving them around, all of that can be paid through Medicaid. So this is an extremely important benefit for our population with disabilities. So again, the two benefits that we're very concerned about are SSI and Medicaid. And as we will see, a person is allowed to have an ABLE account and still qualify for those benefits. Prior to the ABLE legislation, the main really the only tool that a persons with disabilities could utilize for saving money was special needs trusts. Special needs trusts are still an extremely important vehicle for saving for persons with special needs. And again, as we will go through the details about the ABLE account, we'll see that ABLE's not an entire replacement of special needs trusts, but the two can be used in combination. So again, just a very brief overview of special needs trusts, which I think is important before we go too in-depth with the ABLE account. There are two main types of special needs trusts that you should be aware of. And the major difference between them is where the money is coming from that is funding the trust. So I've listed the two types of special needs trusts on this slide. The first is the supplemental needs trusts. This is often called a third-party funded trust, but those are the type of special needs trust that a parent might name in his will in order to have a share go for a child with special needs. If a parent has a child with special needs, it's so important that they modify their estate plan to utilize a special needs trust. If something happens to mom and dad, and if the child inherits money in excess of $2,000, then that child will become ineligible for those public benefits, the SSI and the Medicaid that we just discussed. So it is really crucial that the parent do a new will that names a special needs trust for the child instead of naming that child outright. And again, you know, if that child inherits more than $2,000, then they're going to have issues with their public benefit eligibility. So these special needs trusts are not only for rich people. Sometimes I think people think that, but it's just not the case. So the type of trust that the family would use for their estate plan is this supplemental needs trust or third-party funded trust. As long as that trust is properly drafted, and as long as the parents do advanced planning during their lifetime to modify their will, to change their beneficiary designations, and to make sure that their child is not going to be inheriting money outright, then all their money will go into, all the money for the child will go into this special needs trust. And at the termination of that trust, which is usually when the child passes away, then there will be no payback for the Medicaid provided to that child during lifetime. The other type of special needs trust is the one that we call the self-funded special needs trust. This is one that is created under federal law. States have their own laws that also govern these types of trusts, but there is a federal law that controls. And these are the trusts that are going to be funded with the monies of the person himself with special needs. So if somebody is in a car accident and they get $100,000 from a lawsuit as a result of that car accident, they can put their monies into a self-funded special needs trust and become immediately eligible for their public benefits again. Alternatively, if the parents didn't do that advanced planning to name a supplemental needs trust in their will, and if the child inherits money outright, then the child could potentially put his monies into one of these self-funded special needs trusts. So these trusts have a lot of very specific requirements under law. And it is very important to note that at the trust's termination, any monies left over in the trust are first made available to the state to repay it for Medicaid provided to the beneficiary during his lifetime. With all special needs trusts, both the self-funded and the supplemental needs trusts, they are going to have a trustee who is going to be in control of distributions. So the trustee acts like a gatekeeper, and the trustee has the complete, total, and unfettered discretion to make or withhold distributions on behalf of the beneficiary. So the beneficiary is not going to be able to demand any distributions from the trustee. Also, these trusts are not allowed to pay any cash out to the beneficiary. They're not going to be able to pay all income to the beneficiary. They can't pay an allowance every month. All distributions have to be in the trustee's discretion. Okay. So now that we have a basic understanding of the public benefits that ABLE accounts and special needs trusts protect, and now that we have a general sense of what a special needs trust is, we're now going to turn to the ABLE accounts. So first, who is eligible for an ABLE account? Well, the law that we ended up with said that in order to be eligible for an ABLE account, the person must be disabled before age 26. So this was one way in which the legislation that we ended up with was a little bit more limiting than we originally hoped, because unfortunately, this does prevent persons who become disabled after age 26 from utilizing an ABLE account. There is pending legislation that would increase that age to 46, but that has not yet been passed. When we say disabled, we are referring to the Social Security standard for disability. And essentially what that is an income-based test. Social Security says that if you have a mental or physical impairment that prevents you from maintaining substantial gainful activity, then you can qualify as disabled under the Social Security standard. So Social Security puts out a number every year. They say if you can work and earn over this amount every month consistently, then you will not qualify as disabled. But if you have a disability that prevents you from working that amount consistently, you will qualify as disabled. So what's important to note here, again, so a person does need to be disabled before age 26. They do not need to have been officially determined to be disabled by Social Security in order to have an ABLE account. However, that certainly would smooth the process to getting the ABLE account, because if you've been determined to be disabled before 26, Social Security already has documentation of that disability on file. If we have a person over age 26 who, was disabled prior to 26, but they're already over 26, they never received Social Security before then, they can still apply for an ABLE account if they were disabled before 26, but they must submit a disability certification to Social Security. So that's going to be a form completed by a doctor that describes the nature of the disability and that it began before age 26. So that will be important. And that's important documentation for the beneficiary to maintain as well. Now, who can create the ABLE account? So if we have a competent beneficiary with special needs, he can create and fund his own ABLE account himself. If he's not able to, then these accounts can be created by a legal guardian or agent under a power of attorney. It's important to note that a person can only have one ABLE account. That is in the federal legislation. So you can open an account in your own state if it offers it, or you can open one in a different state if you think that that would be beneficial. I would note that the state of residence, the accounts in that state often have benefits for the residents of that state. For example, in Pennsylvania, if you open a Pennsylvania ABLE account, while you do not get a federal income tax deduction for contributions, you can get a deduction for Pennsylvania income tax. And Pennsylvania has some other benefits as well for Pennsylvania residents. But again, you can only have one ABLE account, so you're not able to open multiple accounts in different states. It's different from special needs trust because a person can have multiple special needs trusts and that will not be a problem, but only one ABLE account. Now, another difference from the special needs trusts is who can create them. So again, the disabled beneficiary himself is allowed to create his own ABLE account, but the beneficiary could not establish his own supplemental needs trust. And then self-funded special needs trusts under the law can only be established by a set group of individuals, which does include the competent beneficiary, the parent, grandparent, legal guardian, or the court. So, with this ABLE account, they're very flexible in that they can be funded by both the person with special needs as well as anybody else. The special needs trusts that we just discussed, these self-funded trusts are really only going to be funded by the beneficiary. And the real reason for that is because any funds left over in the trust are subject to a payback from Medicaid to the state. And then the supplemental needs trusts can only be funded by persons other than the beneficiary. And again, the reason for that is because there is no payback from those trusts. But the ABLE account is unique in that it can be funded by both the beneficiary and other persons. With the ABLE account, the beneficiary can select the type of investments that he would like for the account from the options that are provided by the state. So again, this will vary state to state depending on what they offer, but in Pennsylvania, our ABLE account offers several different investment options. They range from more conservative to a little bit more aggressive, so the beneficiary can select what he would prefer. For special needs trusts, both types, the trustee is the one that's going to be making all investment decisions. So the beneficiary, may be able to discuss it with the trustee, but at the end of the day, it is up to the trustee. One of the major benefits of the ABLE account is that it allows the beneficiary to have a lot of control over the account. Specifically, the beneficiary of the ABLE account can withdraw funds from this account himself. This is completely different from special needs trusts. As I said earlier, the special needs trusts have a trustee who is the gatekeeper and can say yes or no to the beneficiary. So the trustee has to control all trust distributions. But instead, the beneficiary of the ABLE account can actually withdraw money himself from the account and use it as he sees fit. So as you can imagine, this is really one of the major benefits of the ABLE account, and this is why these accounts are able to promote so much independence and freedom among the population of persons with special needs. So again, depending on your state account, there are various potential ways that the beneficiary can withdraw money from the ABLE account himself. Our Pennsylvania ABLE account offers a debit card option, which is remarkably easy and straightforward and really nice for our Pennsylvania residents. I believe a lot of other states do that as well. If you're making a larger distribution, you might request a check. There may be an option to do an electronic transfer to a bank account online or by phone. So again, that'll depend, but at the end of the day, the beneficiary is the one who is controlling what monies can be taken out of the ABLE account. So all of this control and freedom on behalf of the beneficiaries comes with some pros and some cons. The major pro, of course, is that it provides the beneficiary with control and freedom over the use of these monies. This can promote independence, it can teach money management skills, and it truly can increase the quality of the person's life and also just give them additional self-confidence and, make them feel very good that they have these monies that they can use as they see. The major con, of course, is that this could make the beneficiary vulnerable to being taken advantage of by designing persons. Unfortunately, there are a lot of bad actors out there who will take advantage of somebody who might have special needs. I have seen it happen on too many occasions. So, if we have a beneficiary with special needs who has his own ABLE account and has control over it, maybe he could be convinced to take money out and give it away, or do, something that would not be in his best interest. So the beneficiary control is just a major, major difference between the ABLE accounts and special needs trusts. Because the trustee has the full discretion over making payments in special needs trusts, those trusts can provide much greater protection to the beneficiary from potential bad actors. However, it also is going to give the beneficiary less freedom over the use of the funds. All right, ABLE contributions. This is another way where the legislation ended up being a little bit more limited than we originally were thinking. So again, this is another reason why the ABLE accounts are not going to be a complete replacement for special needs trusts. So the amount that a person can put into his ABLE account is limited. It's capped each year. The amount that can be put in is tied to the federal gift tax exclusion. So in 2020, that is $15,000. So that means that a person's ABLE account can only be funded up to $15,000 per year. And that is from all sources combined. So, if I put $15,000 into my son's ABLE account, then that is it. No one else can contribute to his account for the year. They're going to have to wait until 2021. Again, contributions to the account are not tax deductible for federal income tax purposes. Contributions are, however, treated as a completed gift of a present interest. So that means that they will qualify for that annual gift tax exclusion, and you will not need to file a gift tax return if you make a contribution of $15,000 to the account. The contributions to the account are not treated as income to the beneficiary. So, SSI has that really strict resource test. You can only have $2,000 and still get SSI, but it also has very strict income limits. We'll talk about them again in a second, but the point is that if I put money into my child's ABLE account, that is not treated as income to him, so it will not disqualify him for SSI or Medicaid. Now, the tax law that was passed at the end of 2017 included some updates in regard to ABLE accounts. So I listed those on the slide. The first thing that it did is that it allowed up to $15,000 per year of a 529 plan to be rolled directly over into an ABLE account. That rollover will count as the year's contribution, but this is a really great use. I have a lot of clients that had already set up a 529 plan for their child, and maybe they don't have another child to rename as a beneficiary. So they did that before they realized the child would need resource-dependent public benefits in the future. So, previously, if they didn't want to change beneficiaries of the plan, or if they didn't want to use it themselves, they could take the money out of the 529, but they'd be subject to a penalty and taxes, and then they could put it into the ABLE. But now they're allowed to do a direct rollover. So that was great. The second thing is that it did provide a limited exception to that $15,000 per year funding cap. Specifically, it said that if the beneficiary with special needs works and if he is earning income through his employment, then he is allowed to contribute his earnings into the ABLE account in excess of that $15,000. So specifically, he's allowed to contribute his earnings up to the lesser of the amount of his earnings or the federal poverty limit, which is currently $12,490. So if you have an individual with special needs who's working and he earns $15,000, by the end of the year, he can put up to that $12,490 in the account himself from his own earnings. And then on top of that, his parents could contribute $15,000 into the account as well. So that is really a huge benefit. Now, in order to qualify for that exception, the worker cannot have an employer-sponsored retirement plan. But again, that is very helpful and is a way that we are seeing a lot of our clients use ABLE accounts for an individual with special needs who works. So in addition to that annual limit, there's also caps on how much can go into the ABLE account in its entirety. Specifically, it's going to be capped at the limit of your state 529 program limit. So whatever that is will be the same for ABLE. And then also you must note that if the balance of the ABLE account goes over $100,000, then that money over is going to count against the SSI resource limit of $2,000, and the person's SSI may be suspended. There will not be any effect on Medicaid, though. Medicaid can continue. It's just SSI will be suspended until the account balance is back below $100,000. So those contribution limits are also a big difference from special needs trusts. Special needs trusts do not have a limit. You can put as much in each year as you would like. Gift taxes may apply to contributions to certain special needs trusts, to the supplemental needs trusts. And as I mentioned, because of that $15,000 cap on contributions to ABLE each year, the ABLE account really is not going to be a replacement for a supplemental needs trust. If a parent, is doing their will, in all likelihood, they are still going to need to do a supplemental needs trust to protect any inheritance for their child with special needs. All right, distributions from the ABLE account and income taxes. So as we see, contributions to the ABLE account are going to grow income tax-free while they are in the account. And then when the money is taken out of the account, as long as it is used for qualified disability expenses, there will not be any income tax on the growth portion. If it's not used for QDEs, then there is income tax and a 10% penalty. So what are QDEs? Well, we still don't have too much guidance on this, and these ABLE accounts are still relatively new. So I do expect that we will get greater clarity on this in the future. But the law specifically listed the items that I have here as allowable QDEs. So as you can see, they do include a lot of the traditional things that we would use a special needs trust for: housing, transportation, schooling, employment training, health prevention, and wellness. I think that that term can be broadly construed to mean, things that would be for the benefit of the person with special needs. The Treasury and the IRS have specifically said that they recognize this term should be broadly construed, that it should include basic living expenses and not be limited to expenses for which there is a medical necessity. Also, it is okay if the expenditure benefits other persons in addition to the beneficiary. So we know it's supposed to be broadly construed. We still don't have complete clarity as to whether the ABLE account can be used for, say, a vacation or movie tickets or something like that. I think, again, that wellness word can be construed broadly because I can certainly see instances where, a vacation, a respite could be extremely beneficial to the person's wellness and health overall. So, if you have clients that are making expenditures for things like that, I would try to make sure that it is tied to their health and wellness as much as possible so that you have a good argument for it. Again, as we move forward in time and as these accounts get more money in them, we should hear more in this regard. It's very important, in my opinion, that the beneficiaries maintain record of their uses of the ABLE account. Because the beneficiaries have so much control and can withdraw money themselves, I think it could potentially put people in a bad spot if there is an audit or if Social Security asks to see what the monies were used for. So I really would recommend, keeping receipts as much as possible for purchases that are made. The ABLE accounts will report to the IRS both the contributions to the account each year and the distributions that are made. So even if there's no tax due, these will be reported. So again, there is the potential for audit, and I really think it's important that beneficiaries maintain records here. We have our special needs trustees maintain all records, and I think it's just as important with the ABLE account. It's just, again, I think it could put some people with special needs in a little bit of a potentially bad spot because they just may not be aware that they need to maintain records for the distributions. All right, so how do these distributions from the ABLE account affect SSI? Let's take a real quick look at the SSI income rules first. Overall, SSI has extremely limiting income rules. Specifically, a person's only allowed to have $20 of unearned income per month and $65 of earned income per month. Any income in excess of those numbers is reportable and can affect the person's SSI. There's some complicated formulas for how they do that. We don't have the time for that right now, but it has to be reported and can affect the SSI. The types of income that we're looking at is earned income, that's wages. Unearned income is basically any income that is not earned. So if I give somebody $100, that's income to them. If they win the lottery, if they find the money on the street, if they get, other interest or dividends, anything like that is unearned income. They also look at another type of income called in-kind income. This is food or shelter that the person gets for free or less than fair market value. So if a child who is getting SSI lives in his parents' house rent free, then that parent is providing in-kind support and maintenance to the child. That is reportable for purposes of SSI. We're talking about both food and shelter expenses. So the shelter is going to be mortgage or rent, and then also essential utilities, your gas, electricity, water, sewer, trash removal. The theory about this is that your SSI is supposed to provide for the bare essentials of life, which include your food and your shelter. Now, not everyone can afford their food and their shelter on a $783 check per month. So a lot of SSI recipients may need in-kind support and maintenance. So if a person who gets SSI is receiving food or shelter, ISM, then this is what happens. It is reportable to Social Security. And Social Security will say that's in-kind support and maintenance, another type of income, and they will reduce the person's SSI benefit each month. But the good news is that ISM will not wipe out a person's SSI each month. Instead, they apply a rule and they only reduce the SSI by what they call the presumed maximum value, PMV. It's essentially 1/3 of the monthly SSI check. So the PMV amount for 2020 is $281. So if you have that adult child who is living in his parents' house rent-free, and if the adult is getting SSI, that's reported to Social Security, and instead of getting that check of $783 per month, he's going to have his check reduced by the $281. But that's often an okay result because the person can still get their SSI, they can still have their Medicaid. The parents could be providing, say, $2,000 per month of ISM, and the person will still get SSI. But of course, it's not ideal because we are reducing the amount that they get each month. Okay, so back to the ABLE account now that we have an overview of the SSI income rules. So the really important takeaway here is that distributions from the ABLE account are not treated as income to the SSI beneficiary. So that means that they're not treated as in-kind support and maintenance either. So if the ABLE account money is used to pay the beneficiary's rent every month, then that is not treated as ISM, and there is no reduction of SSI. So, one potential great use of the ABLE account is, say mom and dad are able to fund it. We put $15,000 in per year, and then the SSI beneficiary has rent of, $700 a month. The ABLE account can pay his rent, and the SSI beneficiary will still get his full SSI check every month. As opposed to if mom and dad just paid his rent outright, he would have his SSI check reduced by that $281 per month. So, this can be a really good use for the ABLE account. In some states, you'll be allowed to move money from a self-funded special needs trust or a supplemental needs trust. You can move money from the special needs trust to the ABLE account specifically for this purpose. Because if the special needs trust pays the person's rent, then he will also have a reduction in his monthly SSI. So the ABLE account is really unique in this purpose. Again, if the SSI beneficiary's rent is paid by anybody else, so any other family member, any sort of trust that's out there, it is going to reduce his SSI. But if it's paid from the ABLE account, then there will not be a reduction in SSI. Similarly, again, if I give that beneficiary $100 myself that's $100 of unearned income to him. But if he takes $100 out of his ABLE account, it's not treated as income at all. So the distributions are not income. So, this just recaps what I just explained. Basically, a great use for the ABLE account is to potentially use it for housing expenses in order to avoid that SSI reduction. Now, another area where beneficiaries could potentially get themselves into trouble is what happens if they hold a distribution past the month of withdrawal. So the practice point that I have down at the bottom of this slide is the big takeaway. If the person's going to use their ABLE account for their housing expenses, what we want them to do is to set up an arrangement where they can take the money out of the ABLE account in the month, say for September, take it out September 1st, and then pay that housing expense in September. What we don't want them to do is to take it out at the end of the month, say, September 30th, and then pay the rent on October 5th, because then they are holding the withdrawal past the month in which they took it out of the ABLE account. If they do that, the way the legislation is written, it says that if you take a distribution out for housing and if you hold it past the month, then it can be treated as a resource. So it would count against their $2,000 asset limit for purposes of SSI and Medicaid eligibility. So we don't want anybody to do that. It could end up rendering them ineligible for their SSI, and then they'd have to reapply, and it's a whole lot of trouble and work. So the rules are a little confusing because they specifically are saying that's the result that happens if it's a housing QDE. It's treated differently if it's a QDE for a non-housing purpose. So say, for example, I take that distribution out in September. I'm going to use it to pay for college tuition, but my college tuition payment's not due until November. So as long as my ABLE account stays open, as long as I always intend to use it for my college tuition, I don't spend it, and it's somehow identifiable, then it will not count as a resource for Social Security purposes. But again, from a practical standpoint, I think it is really best if beneficiaries are using the monies that they take out of the ABLE account as opposed to holding it, for long periods of time. If they do have to do that, then they must make sure it's not going to be for a housing expense. And they, should get some counsel to make sure they're doing it in a way that will not affect their eligibility. Medicaid payback. The federal ABLE legislation states that ABLE accounts can have a payback for Medicaid provided to the beneficiary after the establishment of the account. So, again, typically this is going to be upon the beneficiary's death. So this will depend on your state and what they say. But your state can absolutely say that when the beneficiary dies, any monies left over must be made available to repay the state for Medicaid provided to the beneficiary, but only after the time the ABLE account was established. So, this is a huge difference from special needs trusts. Our self-funded special needs trusts have a payback for Medicaid provided during the beneficiary's lifetime. So, say you start a special needs trust in 2020 for a beneficiary who's 50 years old, and then he passes away, next year. The payback for Medicaid from his special needs trust can go back for his entire lifetime, but not so with the ABLE account. With the ABLE account, it would only be a payback for Medicaid provided after the account was established. I'd also note that the supplemental needs trust, the ones that families might do as part of their estate plan, those have no payback. So again, this is another reason why I do not think that ABLE accounts would be a complete replacement for special needs trusts. I would note that any monies after that payback from the ABLE account are typically going to go to the beneficiary's estate. Sometimes there's options to have it go to another family member's ABLE account, but if that's not an option, then it will go through the estate. So at that point, the funds might also be subject to any state recovery act. And then we may have to go through the probate process in order to transfer any eventual funds to the other family members, as opposed to special needs trusts, which should avoid probate. All right, so some of the major limitations of the ABLE Act that we've seen here are listed on this slide. First of all, we are limited in how much can be put into the ABLE account each year. So it's going to be that $15,000 or whatever the annual gift tax exclusion amount is, unless, of course, we have a beneficiary who is working, and then he can contribute his earnings up to the federal poverty limit or the amount of his earnings. Additionally, if the account is going to exceed $100,000, then the person's SSI will be suspended until it is back below that $100,000. No effect on Medicaid eligibility, but it will affect SSI. There is a payback to the state Medicaid agency. The accounts are going to report the distributions to the IRS and SSA, Social Security. And a big one, we can only do these accounts if the beneficiary was disabled before age 26. So some of the really great uses that I'm seeing a lot of my clients use these ABLE accounts for is, first of all, if we have a beneficiary who is working, he can put some of his own earnings into this account so that it doesn't bump up against his $2,000 resource limit. A lot of times we have people who are just, limited in how much they can save because of that strict resource limit. I would note that the earnings are still income to the beneficiary in the month that they're earned, but then he can transfer them into the ABLE account so they will not be a resource. A great use for these accounts is to use them for housing expenses so that we avoid that in-kind support and maintenance reduction of SSI. I have clients who may have started an UTMA or UGMA account, a Uniform Transfer to Minors Act account. Once that child is the age of majority, those monies are deemed to the child. So transferring, 15,000 of that into an ABLE account can be a great use. If somebody gets a small lawsuit settlement, a $10,000 inheritance, modest gifts, they're all very appropriate for the ABLE account. The ABLE account can be a nice fund to set up just to give the person more control over a certain amount of monies. Maybe the vast majority is still in a special needs trust, but we have an ABLE account for at least some monies. If they get a lawsuit settlement, we may put the first $15,000 of that into the ABLE account. And if we have a person over age 65 who can no longer utilize a self-funded special needs trust but may need Medicaid planning, if he was disabled before 26, we might be able to use an ABLE account. But all of those great uses being said, the ABLE account is in all likelihood not going to be the only or the best vehicle for a larger lawsuit settlement for most parents to really save for their children or to provide for their inheritance through the parent's estate. And right now, we cannot use these for people who do become disabled after age 26. So we have a lot of clients that are using both a special needs trust and an ABLE account for maximum flexibility and savings benefit. All right, guys, so that basically concludes my material that we have. We may have a minute or two for some questions and answers. I'll defer to the American College people on that. But again, if I did not, if you know, we can, your questions will be provided to me and I can get back to you after today. So I hope that this was beneficial for everybody listening today. Like I said, this is a really important new legislation that we have. I think it is so wonderful in that it really can allow persons with special needs to have freedom over their monies, and you know, is really good in order to provide an additional tool to special needs trusts. All right, well, thank you very much, everybody, for spending this hour with me. I know we covered a lot of material, but there's a lot to cover here. So I hope that you learned something and enjoyed. Thank you very much.